So what did, I think we said last time, correct me if I'm wrong, should the parent-child relationship give rise to vicarious liability? Should the parent-child relationship give rise to vicarious liability? Joe, what do you think?
I say yes.
Why?
Because the parent is in control of the child, therefore should be held liable for the damages that they cause.
Okay, and in control similar to whose control?
Similar to an employee and employer.
That's exactly right. What kind of argument did you just make?
Similar interests.
That's exactly right. So what we're doing is we're taking this relationship that already generates vicarious liability, and we're showing that it is similar to the relationship we're interested in, right? Interest 1, interest 2. But in this case, Joe, the similarity that you're showing is not just some random similarity. They are similar in what way? How did you pick control?
I picked it because both when the employee is in the relationship and acting within the relationship with the employer has control over how the employee acts.
Okay, notice what Joe is doing, right? Is that we're going to treat these two relationships similar because they share a characteristic that mattered to the court when the court made respondeat superior a doctrine for vicarious liability, right? It's not parent-child and employer-employee are relationships that both involve two people. That's true, that makes them similar. But what needs to make things similar, and we see that in this context, because we actually have an articulation of what's important in respondeat superior to make it in a form of vicarious liability, is we know why the court made respondeat superior a form of vicarious liability, right? It was a function of control. So if we have the same control in our relationship that they have in that relationship, then, Joe, we know that the two relationships legally need to be treated
Similarly.
exactly. They need to be treated the same, right? Benefit, same thing, right? You could run the benefit relation, you could run deep pocket, whatever it is, it's going to be a similar interest treated similarly, and it's a really good lesson, right? Because up till now, we've always just assumed that whatever similarity that you found was an adequate similarity, right? But now we're reminded that what's got to make these two things similar is what caused the interest one to be treated the way it was originally, right? This is actually a very, very good lesson for legal writing as well when you analogize yourself to cases. Okay? Like when you say, our situation, our fact situation needs to be treated like this case, right? Because we're similar, right? It's not, and let me explain to you why we're similar. Both of the plaintiffs come from Montana. They're both over 6'3". They both like boots, and they both drive SUVs. No, right? They're similar in the facts that the court said were legally operative in the rationale of the case, right? So that when you're analogizing yourself to a case in a brief or a memo, you're giving me language that says, look, these were the legally operative facts in that case. and we are similar to those facts because they had this fact and I had that fact. They had this fact, I have that fact. They have this fact, I have that fact. Right? But you got to make sure that the reader sees that the facts that you're showing are similar are actually the facts that the court cared about when they made the decision. Right? So it's not random facts that you're analogizing yourself to. Okay. Questions about that? Okay. Well, the other thing, next thing I want to look at, we've done duty, right? We've got how many ways of proving duty, or how many ways of doing duty breach? How many? I forget. How many? Yes, Lisa. What are they? Oh, let me write these down. Okay, so we've got duty, and you said there's 4 ways? Okay, go ahead. What's the first one?
The hand test.
Okay, so we've got reasonable person and the hand test. And remember, all of these right? All of these are mechanisms for proving the same duty, right? The duty in negligence is to refrain from those acts that a reasonable person should foresee posing an unreasonable risk of harm to a particular interest of a particular person, right? So all of these that Lisa is about to list are under that umbrella. They're under that rule. They're ways of proving that rule. Okay, so the first one is to actually look at the reasonable person standard and to do foreseeability by working through the hand test. Okay, so Lisa, you promised me 4, you've given me 1. What's the second one?
Negligence per se.
Negligence per se. What's the third?
Risk.
That's right, res ipsa loquitur. And what was the one that you considered to be the 4th?
The 4th is vicarious liability.
Vicarious liability. Okay. Now, when would you use, Lisa, when would you use res ipsa loquitur?
When the plaintiff's injury fell under the defendant's control.
So, if I were to tie you to the railroad tracks and the train drove over you, then that would be an appropriate usage of res ipsa loquitur. There's actually a song about that, right? Or I think it was, what was it? Ray Stevens maybe, or something. Along Came Jones. No, tied to the railroad tracks. Hell. Go home and listen to it. But anyway, so is that res ipsa loquitur?
Well, the burden of proof has to fall on the defendant, not the plaintiff.
Stop. When did, why in Ibarra did we use res ipsa loquitur?
So what?
Why in Ibarra did we use res ipsa loquitur? Ibarra is the case about the guy goes in for an appendectomy, he comes out with a bad shoulder. Why didn't you just say breach of duty of care? A doctor shouldn't have cut my shoulder the way he did.
It wasn't possible for him to have any control of the situation unconscious.
Well, that's true of anybody who gets an operation. Well, most people get an operation, right?
Something happened to him that shouldn't have happened to him. He was in for an appendectomy and he came out with an arm injury.
So what? Isn't that any med mal thing? Is that you're supposed to go in with, a right result and you come out with a wrong result? I just use res ipsa loquitur. He did discovery, Lisa, and at the end of discovery, he didn't know what. typically, when do we use res ipsa loquitur? When the plaintiff is unable to figure out, right? He did discover everything else, and he can't figure out how and nobody knows. It is a mystery. It is a mystery how that injury took place. I don't know how your shoulder got hurt, right? We know why the woman suffered in her ankle in Boyce, right? Because the guy didn't take it out, and he didn't take it out because he never did an x-ray, right? We know exactly what it was that would constitute the duty, what behavior he did wrong. Res ipsa loquitur, we don't know what behavior the person did wrong because we don't know how the accident happened, right? So if you're going to use res ipsa loquitur, when plaintiff or the exam doesn't know how the plaintiff suffered the injury. And when we use res ipsa loquitur, it takes care of which elements? Res ipsa loquitur goes to what elements? Elaine, what elements does res ipsa loquitur go to? Duty breach, and what else? Close. Cause. How do we know that? Because Elaine, what are the three elements the plaintiff would need help with if he doesn't know how the injury happened? Those three: duty, breach, and cause. I know that my shoulder's messed up, right? I know that my head is bleeding. I just don't know how it happened. Then I need help with duty, breach, and cause. And how does that help come? What happened procedurally in Ibarra? The burden of proof was what? Kaylee? Was shifted from whom to whom?
From the plaintiff to the defendant.
Exactly. We shift the burden of proof. In res ipsa loquitur, we shift the burden of proof for those three elements, duty, breach, and cause. We shift them from the plaintiff to the defendant. So it's no longer the plaintiff must prove that the defendant breached the duty of care, and that caused the plaintiff's injury. Now the defendant's got to prove he did not breach a duty of care. And if the defendant can't do that, then the defendant is liable. Okay? So if we use res ipsa loquitur when the plaintiff doesn't know how the plaintiff suffered the injury, then we must be using these. We must be using these when what? Janice, we must be using these when what? When the plaintiff does know. That's exactly right. So as soon as you get your exam, you say to yourself, do we know from reading the facts how this injury took place, or do we not know? If we don't know, then we use Lisa what? We don't know. You read the exam, it says in the exam, nobody knows how this barrel hit this guy. Then we use what?
Would we still use res ipsa loquitur?
Then we use res ipsa loquitur. If we do know how the barrel hit him, right, then we use reasonable person in the hand test, or we use negligence per se. Oh. Kelly, I'm befuddled, right? Here I am, I know what happened, but I have two doctrines that I can use, and I don't know which one to use. How do I decide whether I use negligence per se or reasonable person in the hand test?
Is negligence per se the one where if there's a violation of statute?
It is that one.
So if there's a violation of statute, then you can use that.
That's exactly right. I use in a negligence cause of action, I use negligence per se if there is an appropriate if there is an appropriate statute, the defendant may have violated. Okay? What makes a statute appropriate? Kelly, what makes a statute appropriate for use of negligence per se?
It has to be, this is, I think I can write it a little befuddled, but, so when you look at the statute, you have to look at it to see if it was the kind of class the legislature intended to protect.
Plaintiff is a member of the class the legislature intended to protect. What else?
If the injury suffered was the type that the statute, the legislature wanted to protect.
That's exactly right. And then the statute must be,
is this the typical case?
Before that.
No.
It's the-
The expected injuries.
it's the overall umbrella for those two. There's two parts of this one. One is in a typical case.
The statute must be an appropriate measure of civil liability.
That's exactly right. The statute's got to be appropriate. So those three criteria are met, then you can use the statute so long as the defendant violated it. Now, if we're using it for contributory negligence per se, then Duran, the difference is that instead of the defendant needing to have violated the statute, pardon? The plaintiff needs to violate it. That's exactly right. So if you're using this to prove duty and breach and contributory negligence, then the plaintiff will be the one who has to violate the statute. Now, what if it turns out, so if there's no statute, Alex, if there's no statute, then you would prove duty and breach how?
With the reasonable person and test.
That's exactly what you would do. Alex, what would you do if you started on this and then you realized either the statute wasn't appropriate or the defendant didn't actually violate it?
And you'd have to go to the reasonable person.
That's exactly right. That's exactly right. If for some reason this doesn't work, you can still try and do that. Okay? By the way, how do you show a statute is violated? Elaine, how do you show a statute is violated? It is not in your notes. It is in your head.
If they did what the statute said not to do.
And how do you know whether they've done what the statute said not to do?
Look at the facts.
No, not right away. You have to break the statute into elements and then apply the elements. How many at a time? One. Right? So when you do breach in negligence per se, Elaine, when you do breach in negligence per se, how do you do it? Do you just say, and he violated the statute?
Probably not.
No. What did you just advise your classmates to do?
To break the statute into elements and see, work them one by one.
That's exactly right. That's exactly what you need to do. So you're going to have to look at that statute, you're going to have to identify what are the elements of that statute, and you have to take each of those elements, turn it into a conclusion, give me a because, and give me the relevant facts that make that statute violated, or that element violated. Okay? So, when would you use vicarious liability? When would you use vicarious liability to make someone liable? Michael, when would you use vicarious liability?
Like an employee situation or?
That's exactly, so you would look, and what would be true of that employee?
That there must be an employee-employer relationship,
That's true.
and they must be operating within the scope of that employment,
When what?
when the injury suffered.
That's exactly right. And those are the two, if you look in the cases, if you look in the law dictionary, those are the two they're going to mention. What's the third one that goes without saying, but we explicitly mention so we don't forget it? The employee must first be what?
Negligent.
That's right. The employee must have met all of the elements for a negligence cause of action before you worry about whether the employer can be held vicariously liable. Right? If you don't have someone liable first, the relationship isn't going to make a difference. The scope isn't going to make a difference. Okay? Questions about duty and breach. Okay, if no questions about duty and breach, there is in our universe a certain circularity, which makes me think that we will ultimately discover that like intergalactic space travel and jumping through hyperspace will be possible because, we think that we have to go linearly all this distance, but I think the universe just like circles around in some way. Because this issue has come up before. Now, the issue that I'm thinking of is recently some overzealous parents did what on behalf of their child that has gotten much publicity? Right? What'd they do, Alex?
They bribed school officials to get them into their schools.
They did. They bribed school officials to get their kids into the schools. Now, everybody's been really excited about the parents and the kids, but what nobody's mentioned is those kids are going into what? They're going into seats in that school. It's like musical chairs. When one person goes into that seat is no longer available, which means what? Someone else doesn't get a chair. Right? I got waitlisted at USC. I know a lot of you will be disappointed because had I been accepted, I wouldn't have been here to teach you con law next year. Right? But I'd always wanted to go to USC, right? And so I was all set. My parents had signed off on the FAFSA stuff, and I sent off my application, and they waitlisted me. I was the top of the wait list. I was the top of the wait list when they stopped taking people. They said, Randy, just in case if anybody drops out of the first year class, you are the person we're calling. Still haven't heard from them. The year's almost over. I think it's too late. Okay. Now, right? Because of that, and again, some of you didn't know this, but because of that, I was forced to attend a different college. Do I have, for purposes of tort law, do I have an injury? And this actually happened before. I mean, we're saying, hey, wait a minute, this is an intentional torts problem, right? They may not have wanted to deny you that seat, but they what? They must have known if they're putting their kid in that seat, they're taking that seat from somebody else. Doesn't matter who, because intent what? Doesn't matter who they don't have to know who they're taking it from, because intent what across people? Transfers. Right? So as long as they know that they're going to be taking that seat away from somebody, it might as well have been that they knew that they were taking it away from me. Right? But the last time this came up, it turned out that the SAT people carelessly, unreasonably, negligently reported incorrect scores. right? This is, I guess, about like 10 years ago or something. Bunch of people had their scores understated by 50, 60 points, whatever. And then at the end of the application season, the SAT people caught it and they sent notes correcting it. Oh my gosh, we're so sorry, but we misreported your score. You were actually 50, 60 points higher. And because of this mistake, there were students who had to pay, to change that. There were students who had to go to like Franklin and Marshall, or maybe Gettysburg, Lebanon Valley, maybe, I don't know, Franklin, Marshall, Gettysburg, on scholarship, and had their scores been correctly reported, they could have gone to Penn for full tuition. Is it an injury? If I bring a cause of action against the SAT people because of their mistake, whether that mistake is their failure to properly supervise their employees this time around, or whether that's not vicarious liability, wanted it to be a negligence problem, right? That is their unreasonable behavior in supervising their employees, so they breached a duty to me. Because of that, I didn't get into the college of my choice. Or because they last time misreported scores, little clerical error in the back room, I don't get into the college I wanted to go to. Have I suffered an injury for purposes of negligence? Do we have a Adrian what? And to answer that question, do we have a what? And to answer that question, do we have a what? Those are all good questions. But to decide whether this is an injury, we gotta have a what? If you wanted to know whether we had a duty, you would go look for a what? If you want to know what the law is, you go look for a what? And where do we find rules? That's exactly right. Do we have a case, Adrian, that tells us whether that's an injury? Not that I know of either. Which means no. Which means what do? I have to make an argument. Okay? So, where might that argument come from? Well, if you look at Procanik or you look at Test Bank, these are cases where someone is arguing that something should be an injury. Right? How are these plaintiffs arguing that something should be an injury? Okay? And by looking at how this issue gets argued in other cases, helps us to decide how we're going to argue that it should be an injury in our case. Now, again, to distinguish, and we're going to see this explicitly in Procanik, right? I think we talked about this last semester. Plaintiffs' lawyers in tort actions always advertise that you pay nothing until you what? That's right, till you win, till you recover, right? Because a lot of tort lawyers are willing to handle cases for plaintiffs on a contingency fee basis, right? I will take, depending on how far into the process we go, I may take somewhere between 10 and 40% of whatever you recover from the judgment, okay? If I am only going to get paid if on a contingency fee basis, I'm getting paid by the hour, then up front, I have to make a correct assessment of that case to see if it's worth doing on a contingency fee, right? Even lawyers who say, I won't do this on a contingency fee, if you're willing to pay them, they'll probably take the case, right? But to take it on a contingency fee basis, they want to assess it. And I think we did this last semester on a three-legged stool. I think of it as a triangle. The first corner of the triangle is liability. Will I be able to prove all the elements of the cause of action are met? Okay, will I be able to prove all of the elements of the cause of action are met? One of the elements is injury. Right? One of the elements is injury. Do I have something here that the court considers an injury? Remember when we were doing strict liability and we said, okay, watch the cases, watch what gets suffered, write it down because those are going to be your injuries that you know meet the injury requirement for strict liability. If you see this, you can say, we have an injury because we have this. Notice we haven't been putting a value on that. We've just been recognizing that it happened. Michael?
The injury would be because you don't get a full scholarship. So
The injury I'm talking about is I didn't get into the college I wanted. Right? I did not get into the college of my choice.
But you can prove it financially, right? I mean,
Stop for a second. That's where I'm going next. Right? If all of the elements, if I can't prove all of the elements, and the injury here that Michael's raising, all I got to prove is that if you hadn't taken that seat at USC, I would have gotten it. Right? If they hadn't given it to you, I would have gotten it. So I didn't get to go to USC. Right? I didn't get a chair at USC. I've suffered an injury. I've suffered an injury. Well, actually, that's it. I did not get my chair at USC. I didn't even need to prove that that's causation when I say if you hadn't bribed your way in, I would have gotten that seat. That goes to causation. I didn't get a seat at USC. I wanted one, I didn't get it. Right? Right? If you can't meet all the elements, you don't want that case as a contingency fee case. Right? Because at the end of the day, the plaintiff's going to lose and you're not going to get paid. So the first question is, can I go into court and prove duty, breach, injury, and cause? Answer's no, I don't take it on a contingency fee basis. You want to pay me by the hour? That's your business. I'm not taking it on a contingency fee basis. If the answer's yes, I go to damages. How much are we likely to recover? Right? And once you establish an injury and once you establish liability, the nature of that injury opens the door to various kinds of damage. Right? Remember back to Carousel Motel, right? The case with the plate. Right? The guy's in line, he's got his plate, he's ready for the buffet. Guy comes through, grabs a plate, and says, "We don't serve you." Okay? Remember the injury there was physical contact to the person. That was the injury. Once you prove physical contact to the injury, physical contact to the person, the injury requirement is met. If you remember back to the case, Once the injury requirement and all the other elements were met, the court went down to damages, and under damages, I could recover both the physical injury I suffered from the plate being pulled from my hand, but I could also recover, anybody remember what else?
Why was he so humiliated?
I could recover for my humiliation and my mental suffering, right? At that time, there was no cause of action for intentional infliction of emotional distress in that jurisdiction. So that humiliation, that severe emotional distress, was not an injury. But once I proved the physical contact to my person that was an injury, one of the damages associated with that injury, right, was humiliation and mental suffering, right? For example, right, in a torts cause of action for negligence, if you suffer a physical injury to your person, among the damages, and we're going to read a case on this, among the damages that you can recover are lost wages, and you can recover pain and suffering, and you can recover loss of companionship and quality of life, right? Lots of things that are associated with damages that we're going to allow you to recover for if we get to damages, but first you got to have the right kind of injury. So injury and damages are two different things. Injury is a particular kind of injury that meets the element. Damages are the monetary things you will be compensated for if you have a cause of action. You know, what is associated. We'll see that with Procanik, that they establish certain kinds of injuries, and those injuries allow for the recovery of different kinds of damages. Okay, so we look at the damages, and say I look at it and I go, wow, it's gonna cost us $60,000 to litigate this case, right? And what are the damages that the plaintiff's going to be able to recover? $40,000. Do I take that case on a contingency fee basis? Let's think about this. I put $60,000 worth of hours into the case. My client wins. We recover $40,000. We went to trial. I get 40%. Means I get paid 40% of 40 is $16,000. What just happened to me? I spent a whole year working to earn $16,000. Do I want that case on a contingency fee basis? No. Right? I gotta look and I gotta say, are the amount of the damages sufficient to justify me working the number of hours it's going to take to win the case? Right? Liability, damages, and then the last one is coverage. Right? If we have enough damages to justify me taking the case, will we ever be able to recover that amount of money? Right? And for that, maybe do they have a house? Do they have assets? Do they have a cash flow? Do they have insurance? Right? Do they have insurance? I'm going to look at those things, and if there are sufficient damages and a sufficient pocket to get that money out of, then I will take the case on a contingency fee basis. Right? But if any of the corners are not covered, then you want to pay me by the hour, that's fine, but I can't take it on a contingency fee basis. Right? All those people who say, I will get you the money that you deserve, and you go, oh, They backed into my car. I think it's about $2,000 worth of damage at the body shop. Do you want it? The answer is going to be no. Right? You're on your own for that one, because by the time I litigate that, it's not going to make a difference in my life. Okay, so anyway, that's where we are, is right here. We're looking at whether something constitutes an injury. Right? And to go back to Michael's question, if we established that not getting into the college of my dreams was an injury, it is possible, Michael, that one of the damages I could recover would be what?
The tuition you ended up having to pay by not getting the full ride.
That's like, if that's like, to go back to the first example or the earlier example, if it's a situation where if you had correctly reported my score, Franklin and Marshall would have given me full tuition. Instead, they only gave me half. By the time they finally corrected the score, the tuition or the scholarship money at Franklin and Marshall is all gone. Then yeah, and I end up going to Franklin and Marshall anyway. Then one of the damages that I would argue under this, I should be able to get lost financial aid scholarship. Okay. What else? Why does somebody pay full tuition at Penn? Why does somebody pay full tuition at Penn when they could go to Franklin and Marshall for free?
It's an Ivy League school, so they figure they'll get a better job and they'll be able to get into a better graduate school or law school.
So I might, Lisa, I might claim what is a damage?
Potential loss of employment or potential loss of getting to a high level.
The future earnings, right? That had I gone to this school, my earning potential would have been higher. Okay? Networking opportunities, right? If I had gone to that school, people who go to that school are, elite, right? And I would have met all these elite people if I'd gotten into that school. Instead, I'm going to have to hobnob with mere mortals. Okay? Of course, on the other hand, you never know what mere mortals are going to do incredibly exciting things. Okay? Your classmates, our alums are partners in New York law firms and Commonwealth Court judges and congressmen and state representatives. But I do have to say that when I was in law school, I was on the board of the Prison Legal Assistance Project at my law school with a candidate for the Vice Presidency of the United States and the wife of the future governor of Virginia, right? So if the LSAT people had misreported my score, I would have lost that opportunity. And in fact, when he decided to run for vice president, right, I sent him a note, which he never answered.
When I run, I'll send you.
Thank you, because that will help me heal that wound. Yes, Kaylee.
Can I just say nobody feels bad that you went to Harvard?
Why do you think I went there?
It's on your bio on the website.
Oh. Actually, Kaylee, to correct you, there are a lot of people who feel bad that I went there, but they're all there and not here. So yeah, there's a lot of regrets there. That, but anyway, Anyway, we're on Procanik. So, what are the injuries? What are the injuries that are discussed in Procanik? Actually, let's even back up a step. What happens in Procanik? What happens? Yeah, Janice.
The plaintiff is the son, and he brings a suit for wrongful life, that he should not have been born because he was.
Okay, so the injury that they're arguing about is something called wrongful life. Wrongful life being, as Janice said, I should never have been born. Right? That's the injury that he's seeking to get recognized. Okay? And if he gets that injury recognized, what are the damages that he would like to be able to receive? What are the damages? Yeah, Duran?
I don't know the number, but he's talking about like the extraordinary expenses that he incurs.
Okay, so one thing that he wants to be able to recover as a damage, right? So here's my injury, here's my damage. One thing that he would like to be able to get is extraordinary medical expenses. Right? And so what's the relationship? What's the relationship between not being born, extraordinary medical expenses? What's going on here? Yeah, Duran?
Well, if he wouldn't have been born, he wouldn't have incurred any of those expenses because I guess of his birth defects. Yes, continual.
So this is a child who was born with a high degree of what we would call birth defects, right? Which require all sorts of medical attention. And if the doctor had alerted my parents to genetic screening, and if they had received genetic screening, they would have aborted the pregnancy, I wouldn't have been born, and there wouldn't be all these expenses to get me through life. So one is extraordinary medical expense. What's another damage he would like to receive? Janet?
General damages for pain and suffering because his parents have to cope with his.
That's right. So, well, say that again. I got excited.
General damages for pain and suffering. Oh, there's an and in there, and for his parents' impaired capacity to cope with his.
Stop for a second. The parents coping comes with what injury? It's not wrongful life. Let's hold that for me, right? This mental suffering, right? This mental suffering. If I had been aborted, if I had never been born, the pain that I suffer associated with this disabilities, I would never have had to endure, and I should be able to recover for that, right? So we have that as a damage that he would like to recover as well. Now, just so we don't get confused, the court is ultimately going to decide which of these are recoverable, which of these are not recoverable. Lisa, what's recoverable, what's not?
The extraordinary medical expenses are recoverable,
Yes,
but the supplemental suffering is not.
that is exactly right. So the court is ultimately going to decide that for wrongful life, you can recover the extraordinary medical expenses. You cannot recover mental suffering. This is not a damage associated with that injury. Okay? Now, because, and this is one of the great coincidences that occurs in our universe, right? If you take a tort case, personal injury case to trial, normally the lawyer who tries the case is going to take 40% as the contingency for recovery of what you recovered, right? If it actually goes to trial, it's probably going to take 40%, or she's probably going to take 40%. Typically, in a personal injury case, the amount of the recovery represented by pain and suffering is about 40%. It's an incredible coincidence. So what happens? Normally, so your lawyer takes the legal fees out and you're left with your out-of-pocket expenses. Right? So you suffer for free, as it turns out. You suffer for your lawyer, but you end up being made whole, at least as to your monetary expenses. Right? That's not going to happen here. Right? Because he's not going to get anything for mental suffering. Right? He's going to get compensated for his extraordinary medical expenses, but the lawyer's going to take a cut of that. So that's when, Janice, that's when the lawyer says, and the client, wait a minute, if we can't recover mental suffering for wrongful life, we'd also like to claim a cause of action for another injury. And what's the other injury that we're claiming? Stop. That, and we put that up, but that's not the one we're looking for. Wrongful birth. Wrongful birth. Just so we're clear, who's bringing the wrongful life action? Lisa, who's bringing the wrongful life action? The baby, the kid, right? Offspring, right? The offspring. Who brings a wrongful birth claim? Elaine? Parents. Right? The parents bring wrongful birth. At the time of Procanik, it is established that you can bring wrongful birth. Didn't always, and we're going to talk about how that came to be. Couldn't always bring wrongful birth, but by the time you get to Procanik, you can bring a wrongful birth action. Why don't the parents just bring wrongful birth and not worry about paying the lawyer to bring this wrongful life action? Very interesting dynamic. What has happened to the parents' claim? What has happened to the parents' claim that makes them try and recover on this odd sort of wrongful life action when they should have just been bringing a wrongful birth, which is already accepted as an injury? .494, fifth paragraph. 494, fifth paragraph. April, read me that 494, first sentence, fifth paragraph.
The present case proves the point. Here, the parent's claim is barred by the statute of limitations.
Stop. What happened?
They could bring it.
That's right. By the time the parents figured out that they wanted to bring this as a cause of action, statute of limitations had already told as to the parents. But it had not told as to the child. Right? Either because since he was in a minority, the state laws might have said that he has until majority before it starts running on him, or it may have been because you got to be born before it starts running, and so he had an extra 9 months over the parents, whatever it was, right? His statute of limitations is still ripe. The parents has already told, right? So he brings this wrongful life action. Now, under wrongful birth, we should not have had to be parents. This is, I should never have been born, I shouldn't be alive. This is, we should never have been parents of this child. what are the damages that the parent can recover? Yeah, Lisa?
The cost of caring for a child that has.
Right, so they get the extraordinary medical. They get the extraordinary medical.
And emotional distress.
And they also get the mental suffering. Right, so they're yes, and they're yes. Right, now, that brings us, Janice, right, the kid is like, wow, I got to figure out some way to get some mental suffering here because I want to be made whole, right? I got to make up the difference here. I wasn't able to get the mental suffering over on the wrongful life thing. So the child says, you know what else? I also want to claim a lawsuit for what?
His parents' impaired capacity because.
And what does he call that? That's exactly, what's that called? 495, 1, 2, 3, 4, fifth paragraph, as speculative and uncertain.
As speculative and uncertain as is the comparison of the value of impaired life with non-existence, even more problematic is the evaluation of a claim for diminished childhood.
Okay, diminished childhood. And what is diminished childhood as an injury? What is diminished childhood as an injury? Kelly, what's diminished childhood as an injury?
So you didn't have the full childhood that a able-bodied child would have?
Actually, they're comparing something else. Kelly, let's look at this. Read, starting with the essential proof in that paragraph.
The essential proof in such a claim is that the doctor's negligence deprives the parents of the knowledge of the condition of the fetus. The deprivation of that information precludes the choice of terminating the pregnancy by abortion and leaves the parents unprepared for the birth of a defective child, a birth that causes them emotional harm. The argument proceeds that the parents are less able to love and care for the child, who thereby suffers an impaired childhood.
Okay, so what's the kid arguing there?
That is,
If you just what? The doctor, if you had just what?
terminated the pregnancy.
Not terminate the pregnancy. They kind of get that little twist around, but what? If you had what, my parents?
Given the information to the
Because
parents.
if you'd given them information, if they knew I was coming, if they knew what I would be like, then what would have happened?
They would have terminated the pregnancy.
No, what does it say? If they would have
Oh, they were
known.
unprepared for the birth of the defective child.
Yeah, and therefore what did I lose?
The affection.
That's right. I lost the love and care of my parents. Right? If they would have known I was coming, they would have been prepared for me. And if they were prepared for me, they would have embraced me. I would have had a better childhood. I would have had a better start. And my life would have been better. And I should be able to recover for that loss and affection that manifests itself in the poor start that I ultimately get. Right? And the court, yes or no to diminished childhood?
Sorry, were you still on me?
Yeah.
Okay. No.
No, you cannot recover for diminished childhood. Why not? And this is kind of interesting. Bottom of 495, Kelly, over to 496. What's it say?
At the outset, we note the flaw in such a claim in those instances in which the parents assert not that the information would have prepared them for the birth of the defective child, but that they would have used the information to prevent that birth.
Stop. What are they saying there?
But instead of preparing the parents for the care that they would need, they would have aborted the child.
Why do we think they would have aborted the child? Because the child is doing what? What was the first, Kelly, what's the first cause of action we looked at? First cause of,
Money, liability.
wrongful life, right?
Yeah.
What's the premise of wrongful life? I should never have been born. I should never have been born, right? And then he turns around and the only way that you cannot be born is if you're not born. It's kind of profound, if any of you want to quote me on that, right? Wait a minute, down here you're saying, if the doctor had provided the information he failed to provide, you would have been born and your parents would have been prepared for you and they would have loved and nurtured you. What's the problem? You can't have it both ways. Right? That's what the court says in this case. Wait a minute. It doesn't work in a case like this one where you've started out by saying, I should never have been born. I'm entitled to extraordinary medical expenses because these should never have been incurred because I shouldn't be here. And then you turn around and say, if this information had been provided, I would have been born and my parents would have been ready to deal with me. You can't be born and not born at the same time. Question to ponder as we go through this case, what if the parents forego a wrongful life and wrongful birth action? What if they only bring diminished childhood? I want you to think about, should that be a cause of action if they choose not to bring wrongful life and wrongful birth? And it's actually to me kind of a vivid dynamic, the diminished childhood, because our third child, when she was born, she did the first 3 months in the NICU unit, right? She was 2-8 at birth, right? So she's doing the first 3 months, and I'll never forget, you do 3 months in the NICU unit, you get used to the routine, right? So you just, scrub up for an hour and a half, and then you go in, right? So it was scrubbing up, and there was one day, there was this brand new mother whose child was in the NICU unit, and she's standing at the window, and her husband is trying to get her to go through the door. And she's like, no. If my baby wants to see me, my baby needs to get to 3.5 pounds. At 3.5 pounds, but she's got to get to 3.5 pounds. I'm not going in there to see her. She's got to come out here to see me. Okay? And I just kept watching, because in that situation, you can't say, she doesn't have great communication skills right now. Right? So you can tell her that, but she is a non-social policy deterrence commodity at this point. She cannot change her behavior. Okay, but, right, this is not necessarily fictitious. Right? This woman has just had a baby. She's got all these expectations for what should happen. She's had this picture of what was going to happen after the baby was born. None of that's happening. It's all shattered. She's being a little irrational. What would the world have looked like if she had known 3 months ago she was going to have a 3-pound baby? And it was going to be in the NICU. Maybe she would have been ready for that, and she would have walked through that door and held her baby. Right? And the key to fattening up, this is true. It's kind of an interesting dynamic. The key to fattening up babies in the NICU unit, holding time. Right? Nothing stimulates growth better than holding a baby. Right? So anyway, so that baby had a cause of action against whoever, because he would have gotten to 3.5 pounds so much more quickly. She just would have gone in there. But anyway, so there's another cause of action kind of floating around that I want you to be pondering. Page 494. Rob, page 494, third full paragraph starts out with a child.
When a child requires extraordinary medical care, the financial impact is so felt not just by the parents, but also by the injured child. As a practical matter, the impact may extend beyond the injured child to his brothers or sisters. Money that is spent for the health care of one child is not available for the clothes, food, or college education of another child.
Who else does that suggest might have an injury?
Sibling.
Sibling. Wrongful siblinghood. Is that an injury? So what would be the damage? Okay, so we've got this kind of dynamic going on here. So what happens is in New Jersey, originally you don't have wrongful birth, you don't have wrongful life when a doctor fails to give parents information that could lead to genetic screening and ultimately termination of pregnancy. And they start out, they don't have that because in New Jersey, you couldn't terminate the pregnancy anyway. So there's no cause, right? My failure to provide you with this genetic information didn't cause the child to be born, right? Because once you have conceived that child, there's nothing in New Jersey you can do about it anyway. Now you still, if they had been clever and imaginative enough, you still might have been able to bring what? Rob?
Wrongful siblinghood or
Not wrongful siblinghood, because that baby's going to be born.
diminished childhood.
Diminished childhood. Right? We don't know if that's a cause of action, but that's still a thing. If my parents had been warned, they would have embraced me, right? Even before you had a right to abortion, that was a dynamic out there, right? Nobody brought it. Okay? So anyway, along comes Roe versus Wade. And Roe versus Wade, and kind of interesting, you don't normally think of this, but constitutional law has an impact on tort law. And Roe versus Wade guarantees a woman the right to terminate a pregnancy, which means that the New Jersey prohibitions are no longer good law, right? Which means suddenly the doctor's failure to provide the genetic screening information can be a cause of the parenthood and the life, right? So the court, right? So the court first says, all right, parents, you have a cause of action for extraordinary medical expenses and mental suffering. Why? Why yes, why no? Page 491. What's the first problem? Bottom of 491. What is the first problem? Joe, what's the first problem? Bottom of 491.
At the very bottom, this is the court denied the parents' claim for emotional distress and the cost of caring for the infant because the impossibility of weighing the intangible benefits of parenthood against the emotional and monetary injuries sustained by them. So it's like not really measurable.
That's exactly right. If you're going to say that something is an injury, if you're going to say that something is a damage, then you need to be able to do what? Joe, what do you have to be able to do?
You have to measure it.
You're going to have to be able to measure, you're going to have to be able to quantify it, right? And that again, right, to think back to our example of not getting into the college of my dreams, is that an injury, is that a damage that we can quantify? If at the end of the day we can't, there's no point in creating tort liability for it and then get to the end of this lawsuit and saying we can't put a number on it, right? So there's always an argument. We can or we can't quantify this particular injury. Why can't, Joe, why can't we quantify that? Or what's the claim?
So they said it's like intangible, prevailing policy considerations, which included a reluctance to acknowledge the availability of abortions and the mother's right to choose to terminate the pregnancy, prevented the court from awarding damages to a woman for not having an abortion. Another consideration was the court's belief that it is basically the human condition to seek life and hold on to it, however heavily burdened. So I guess they're saying it's intangible.
Okay, so one problem is, right, that it is value, it's intangible, as Joe said. You can't put a number on it. And yet the court ultimately rejects that, or the courts later in the progression reject it. Why? Right? What are we saying there? We're saying that we can't quantify mental suffering versus absence of life. We can't do that. The court ultimately comes up, particularly with the parents, they say what? Actually, with the parents, we what? We do that all the time. When? We award damages for potential infliction of, Elaine, what? Emotional distress. We quantify emotional distress all the time. At least for the parents. Why do you say we can't? Right? That is quantifiable. Okay? So the court rejects the logic of the argument. Yeah, if it was true that you couldn't measure it, we would say that it can't be an injury, but you can measure it. We do it all the time. Okay? With the kid, it's different, right? With kids, it's different because there we've got to make a comparison that is, you've gotten the benefit of being alive, and the legal system has a presumption that what? Life is better than non-life, right? That we have that presumption. So you're getting the benefits of getting a life. It's not it's got pain and suffering associated with it. That one we can't do, right? Because how do you begin to quantify the value of life or whatever? I mean, the court, that one they shut down on. There's a couple other problems there. One, we're going to call it administrability, just measuring that's impossible. The other thing that I want you to be sensitive to is courts apply what? Right? You came to law school and you thought that I would leave you alone, we wouldn't have to do policy because courts were just going to do what? Lisa, what do courts do? What kind of school are you in? Law school. Courts do law. They do rules. Right? What don't they do? They don't do this mamby-pamby policy value subjective nonsense. Right? That's not what courts are about. That's what the law is about. Right? And so if we create a rule that gets into the value of life, it's going to be inviting courts to do things that what? Lisa, it's going to invite courts to do things that they're not what?
Really prepared to do.
They're not prepared to do or not supposed to do. Right? And particularly with an issue like this, right? Turn this one over to a jury. Right? Whoa, wait a minute. We're not going to get, we're not going to be getting anything like real numbers. We're going to be inviting all of these emotions and values and all this other stuff. The jurors are going to be applying to this case. Nobody is going to be doing what they're supposed to be doing here. Right? Institutional competence. Not only do we have to look to see if it's possible to do, but we also have to look to see whether it's what we want people doing. Right? Does this involve people doing things we don't want them to do? Right? Next year, you'll see this in con law as separation of powers. There are kinds of decisions that legislatures are supposed to make. There's kinds of decisions that courts are supposed to make. There's kinds of decisions the president's supposed to make, right? Kinds of things that each of those branches are supposed to think about, right? You don't want to be moving a decision or having a branch make a decision that they don't really have any business making, because it's not what they do. And that's what the court is saying here. Wait a minute, we don't want to get into a very value-laden decision that nobody's prepared to make. Okay? As we said, right? The court ultimately decides the parents can recover for extraordinary medical and mental suffering. And then they extend that to the child based on similar interests treated similarly. Right? Recovery of the cost of extraordinary, 494, fourth paragraph, recovery of the cost of extraordinary medical expenses by either the parents or the infant, but not both, is consistent with the principle that the doctor's negligence vitally affects the entire family. Right? What the doctor has done has disrupted the family here, and we allow recovery. It's the same disruption over here, and it's the same behavior over here. And if it's the same disruption and the same behavior, then we should get the same result. Right? Right? And the court, so we've got similar interests treated similarly. And then we also have, Bob, read me the paragraph starts out, law is more, on that page. Fifth paragraph.
Law is more than an exercise in logic and logical analysis, although essential to a system of ordered justice, should not become an instrument of injustice. Whatever logic inheres in permitting parents to recover for the cost of extraordinary medical care incurred by birth defective child, but in denying the child's own right to recover those expenses, must yield to the injustice of that result.
Okay, so now we're worried about what? What's injustice here? We've got innocent parents, we've got a doctor who messed up, right? And we want to make sure that there's adequate money that goes to between an innocent and a wrongdoer, who should pay?
To the innocent.
That's right. Right? Read me the last sentence in the first block of text on 495.
We seek?
Mm-hmm.
We seek only to respond to the call of the living for help in bearing the burden of their affliction.
Okay, what does that mean? What are they saying? We seek only to respond to the call of living for help in bearing the burden of their affliction. What are we doing here? Is that innocent and wrongdoer? Do we care whether the doctor's a wrongdoer? What are we trying to do? Why are we allowing recovery? We're responding to what?
To the call for assistance for the...
That's right. We have a need. And when we have a need, we go out and we look for a solution. And the solution we found is the doctor's insurance policy. Right? What kind of argument?
Social policy... deterrence.
Not deterrence. Right? I'm not trying to change anybody's behavior. We'll come back to that one in a second. They don't argue that, but we'll come back to that in a second. What are we doing? We're looking for money. What do we call that? Deep pockets. Right? My job as a little, remember, separation of powers. What's the court's job? Right? Another question about the court's job. Is my job to deter inappropriate behavior or punish wrongdoers? Or is my job to manage disasters and make sure that there's money to compensate it? And the court there is saying, my job is to make sure that when there's an injury, the person who's in the best position to bear the cost of that injury bears it. So I'm going to slide the cost of these medical expenses over to the doctor. Right? And you may argue inappropriate value, not what courts are supposed to do. But that was the value we saw in what case? Where did we see that value? First day of the semester. The more beneficial the activity, the more likely it should be called abnormally dangerous. Why? Because very beneficial activities make lots of money, and so they should bear the cost of the people associated with that activity that get hurt. Right? And Cyanamid turned around and said, no, that's wrong. This is about deterring inappropriate behavior. So Bob, if this is about deterring inappropriate behavior, we could say, wait a minute, we've got a what here? We've got a doctor who messed up, and we need to make sure that he gets held to somebody to make sure that he cleans up his behavior in the future, or doctors in his position clean up their behavior in the future. Right? Why do we want to call the failure to get into college of my dreams an injury? Well, one reason is that lots of people depend on the college board. And when they screw up, we gotta what? Gotta hold them liable. Because that'll make sure, Bob, that in the future when they send those scores out, they won't screw up. That's what we're going to call an injury, social policy deterrence. Or, Kaylee, you could also say, hey, every time somebody takes one of those tests, they're paying $50 or $60, plus they're paying $40 to get their scores, plus they're paying another $50 to get their super explanatory score sheet, and then they're going to take it 4 times again, because that's what you do when you're in college, or when you're trying to get into college. So the folks out of the college board are what? They're making a lot of money, right? And we got these poor people who are about with very little money saved, and they're about to head off to college and spend hundreds of thousands of dollars trying to get a degree. Who should bear the cost? The people making money, right? That's an injury, and we're going to allow you to sue because they got money and they can compensate you. Okay, so anyway, I want you, as I said, I want you to think about if the kid says, if the parents say, we would not have terminated the pregnancy, if they vow that they would not have terminated the pregnancy and they don't seek wrongful birth or wrongful life, should there in that situation be a cause of action for diminished childhood? Should there be a cause of action for wrongful siblinghood? Should a sibling, if a parent chooses not to, notice these are not duplicative. You only get extraordinary medical expenses once. You can't sue for both. Choose one or the other, right? So you couldn't all 3 of these get the extraordinary medical expenses 3 times. But if the parents and the child choose not to seek, should a sibling on their own behalf be able to seek? Okay? So think about that. We'll take a look at test bank next time. Test bank again, just to see what kind of arguments they're making for what injuries are recoverable, what injuries are not. We will on Monday, we'll take a look at Reynolds, Hill, and Anderson, and Kelly. Beyond that, for Sears, I just want you to look at you don't have to read the case, I do want you to look at the kinds of damages that they award for somebody who suffers a physical injury to person. So take a look at, and just look at the list of injuries that you're allowed to receive. And then I will tell you what you need to know about affirmative defenses, plaintiff's conduct immunity. Still worry about reading those cases. And so once we get through with Kelly, real quick, with Kelly, it's an example of doing cause of proximate cause and duty in the same case. It's Andrews and Cardozo together. So just be on the lookout for that. But anyway, we'll try and get as much of that done on Monday so that on Thursday and the following Monday, we can just work on reviewing. Okay?